Thank you, everyone. Thank you for being with us. I'll start with brief introductions. My name is Barrister Sakib Mangio, and I'm the Assistant Director Law at the South Arbitration Council. It is my privilege to welcome all of you to this important webinar on digital innovation in ADR, India's role, and SARCO's collaborative vision for South Asia. This event is being organized by SARCO in collaboration with the South Asian University. I want to take this opportunity to express my gratitude to our highly distinguished speakers and to all of you, to all the participants who have taken the time to join us. Your participation is what makes this webinar a valuable platform for dialogue and development. The focus of today's webinar, Digital Innovation in DDR, goes to the heart of India's transformation towards a faster, more accessible, and business-friendly dispute resolution ecosystem. As transactions scale and supply chains digitize, disputes are inevitable. Relying solely on traditional paper-heavy processes is costly and slow. From online dispute resolution platforms and virtual hearings to AI-assisted case management and e-filings, technology offers practical pathways to speed, transparency, and proportionality without sacrificing due process. Digital EDR tools can narrow issues earlier, reduce procedural friction, and expand access beyond major metros, keeping parties in control while strengthening confidentiality, data integrity, and enforceability. In India's context, embedding these innovations into institutional rules and everyday practice can relieve pressure on courts and tribunals, improve predictability for investors, and set regional benchmarks. And through SARCO's collaborative vision, India's leadership can help knit together standards across South Asia so that technology not only resolves disputes faster, but also builds a more trusted, connected EDR marketplace for the region. As we begin, I invite all the participants to openly engage with our speakers and to share their questions and their practical insights. It is through this exchange that we will identify workable reforms and build professional capability and chart a clear path towards a sustainable EDR culture in SARC. Here's to an engaging and productive session ahead. Now that we have formally started with this webinar, I'd now like to introduce our current presiding Director General of SARC Arbitration Council, Mr. Choining Doji. Mr. Doji is a seasoned legal practitioner and has previously served as a member of the National Council in the Kingdom of Bhutan. Additionally, Mr. Doji has also served in the Royal Civil Service Commission of Bhutan as well as in the Anti-Corruption Commission of Bhutan. Mr. Doji is our fifth Director General, and it has been due to his guidance and support that SARCO has been able to continue its important work of promoting the use of EDR in the SARC region. Please allow me to welcome Mr. Doji to give the opening remarks.
Governing board member, Judge Ruhul Amin from Bangladesh, and our governing board member, Mr. Khurram from Pakistan, two professors, Dr. Ritu Gupta and Dr. Kavi Sharma, the participants joining us from different locations. A very good afternoon. I join my colleagues in welcoming all of you to this webinar, particularly to our 2GB members and two resource speakers, two doctors from ACU. And we organize a series of seminar, webinar, other lecture series, and also specific training programs in member states year after year. Today's webinar is one of the series we have planned for India. And this is mainly because the SARC Arbitration Council's mandate includes our responsibility to promote and assist arbitral institutions in the member states. So pursuant to this mandate, we are doing this, organizing this kind of webinar, workshops, trainings, and other lecture series. I think my colleague has said a lot about the program. So I will not elaborate much further on this because I guess participants really want to hear more from our two speakers rather than us sitting here and speaking. But if you look at the program activity, I mean the topic of the webinar today is the proposal to explore the use of ICT in the areas of ADR. I think this is a very fascinating topic and very emerging topic, and is relevant to all member states. And I hope, as my colleague mentioned earlier, you engage actively with the participant, other colleague participants, especially the resource speakers. This is a free interactive session, and I guess the webinar is good as how we interact with the resource speakers as well as with the participants. So I encourage all of you to interact with the speaker and also interact among yourself. I mean, you can ask a lot of questions, as many questions as possible. I think this is the only way to make the webinar very interesting, interactive, and we can really share the ideas or get ideas or knowledge or expertise from our two speakers, Professor Redu Gupta and Professor Daksha Sharma. Yes, for me, I am really looking forward to this webinar. And I hope the participant engages with us, and I hope I wish the participant very successful, engaging, and productive webinar. Thank you.
Sure. Ladies and gentlemen, our main thematic session for today is an overview of digital innovation in the ADR landscape in India and how this translates into possible capacity building specialized training programs. To deliver their insights on this topic, we are lucky to have two renowned speakers, namely Dr. Daksha Sharma and Professor Rizu Gupta. Just to give a very brief introduction about our speakers, Dr. Daksha Sharma is an assistant professor of law at the South Asian University in New Delhi and serves as an arbitrator at Prasar Bharati. She is also a visiting faculty member at several prestigious institutions, including the Delhi Police Academy and the Indian Law Institute, where she regularly lectures on constitutional law, ADR, international law, and human rights. Dr. Sharma is the founder of Rising Stars, a community service program focused on the right to education for children in New Delhi. She has held key academic and administrative roles at Bennett University and Amity Law School. Dr. Sharma holds a PhD in international law from the Indian Law Institute and has practiced law, contributing excessively to socio-legal seminars and research publications. Alongside Dr. Sharma is Dr. Professor Ritu Gupta. Professor Gupta is a professor of law at the National Law University Delhi, NLUD, currently on leave at SAU. She has served as research director of NLUD's Center for Business and Financial Laws and previously taught at USLLS and VIPS. Her specializations span commercial and business laws, contract, banking, property, and competition, alongside interests in legal education, judicial process, statutory interpretation, and gender justice. She has authored two LexisNexis books, Sexual Harassment at Workplace and Law of Contract, including the specific Release Act 1950. Recognized with an PSLI visiting fellowship at the National University of Singapore, Professor Gupta has been named among BW Legal World's 100 influential women driving change in the Indian legal ecosystem, ranking in the top 5 academicians for 2 consecutive years. Professor Gupta serves as an external expert on internal complaints committees for the Cabinet Secretariat, Rashtrapati Bhavan, the Office of the Principal Scientific Advisor to the Government of India, and the NHRC. Previously, she held roles with the Prasar Bharati, the MWCD, and the CCI. She has been a member of NHRC's core group of women, an external expert on the advisory board of NHRC's Hindi magazine, Nai Dishaएं, and on boards/referee panels, including the NCRB. She sits on the editorial board of the CCI Journal and reviews for World Development and SAGE. Her honors include the Rex Karamveer Global Fellowship and Karamveer Chakra Award. and ICSSR Doctoral Fellowship, and CSR's Miss Superbrain Super Personality. Dr. Sharma and Dr. Professor Gupta, we are extremely grateful to have you on our panel of speakers. And now I'd like to invite you both to take the floor.
Thank you so much, Mr. Barrister Mangrio, for introducing us. Now is the time to move towards the main part of the program, that is a discussion on the introduction of ICT in our systems. So for that, I request you, if you can please have the PPT here so that we can share with our participants and move as per the slides.
Sure, Dr. Sharma, just give me 1 second.
Thank you. I hope the PPT is visible to everyone. So as today's topic is about digital innovation in ADR, India's role, and SARCO's collaborative vision for South Asia. So we will be covering major aspects related to ADR. What are the means and methods in ADR? Why ADR is important and why digital innovation in ADR is significant. I request Mr. Barrister Mangrio to please uh, go to the next slide. Thank you so very much. So these are going to be the contents of our presentation today. The first three topics will be dealt by me, and the last three complex topics related to international commercial law and arbitration shall be dealt by Professor Dr. Ritu Gupta ma'am. First of all, I pay my regards to everyone who is present in this webinar. My greetings to Honorable Director General of SARC Arbitration Council, to Mr. Barrister Mangrio for organizing this program, to my esteemed senior of the department, Professor Dr. Ritu Gupta, and all other participants who are present for this webinar to have an open discussion. So as you can see, the first slide about the introduction, like the topics we are going to cover, alternative dispute resolution and how mediation is become its most popular way. Second is related to access to justice and the concept in these topics, I would be covering amicable dispute settlement, win-win situation if ADR is employed, and how ADR is responsible of court and litigation processes. Also, these days it is observed that we have moved from access to justice. We are not only talking about doorstep delivery of justice, but also we are talking about the methods that is at every stage. Next point will cover significance of digital innovations in ADR, and rest of the points resolution, Indian context, way forward for India and South Asia, conclusion and suggestions shall be shared by my esteemed team. Now I request Barrister Mangrio to please change the slide. Thank you so very much. As we can see here, that should be dealt upon. For example, the first part itself, it's saying that alternative dispute resolution, arbitration, conciliation, mediation, and several new approaches are there. For example, MEDARB, MEDOLA, ARB, is that why ADR is significant, why these approaches are important. So, of course, to answer this, ADR is significant because it aims to resolve the dispute in a time-bound manner. And when we say time-bound manner, it indicates that it is towards the speedy justice, it is towards the rights related to access to justice. In the second part, as we can see here, mediation is becoming a very important part of ADR because it is a speedy and cost-effective settlement of dispute. Now, when we broadly speak about alternative dispute resolution, it is a method or a mechanism or a technique of dispute settlement outside the court. That means that we are going beyond the traditional norms of dispute settlement, of litigation, and we are trying to see that, how disputes can be resolved effectively and in a speedier manner. Also, it is important to learn some of the contemporary reflections as far as the international and national perspective of ADR is concerned. And we are going to see that how these laws are enacted and what is the role of judiciary. Next slide, please. As far as the evolution of arbitration is concerned, the practice is not new, and we can see that this practice dates back to 600 BC. This practice is formulated in terms of Jay Treaty of 1794, the treaty which is significant for introducing changes as far as the arbitration regime is concerned. So the treaty that happened between Great Britain and US is defining the significant aspect of alternative dispute resolution, especially in the context of arbitration. It is also pertinent to note that there are various other treaties in the international domain, for example, Bryan treaties, that have significantly led to the establishment of systems with respect to ADR. And then we see the establishment of permanent court of arbitration that within the span of 1900 to 1932 was able to settle 20 cases of arbitration. And then we have Hague Conventions of 1899 and 1907, Geneva Protocol 1923, UN Charter Article 33, that is specifically pointing towards having the peaceful resolution of disputes. Other conventions worth notable are the New York Convention 1958, the European Convention 1961, and of course, the Model Law on International Commercial Arbitration of 1985. The UN CITRAL is making great efforts in this direction. And also, it is worth mentioning because we had the opportunity to work with SARCO, and still we are working in projects with SARCO. So it is worth noting, and it is to be highlighted that even the system of SARCO is aligned with the UN CITRAL Model Law on International Commercial Arbitration. Next slide, please. Now, because the topic is all about introduction of ICT in the Indian and South Asian context. So first, let's try to understand the evolution of arbitration in India, how this concept was evolved. So again, like as stated, that arbitration as such is not a new concept. It is an age-old concept, and the same is reflected in the ancient text also. If you consider Brihadrank Upanishad, if you consider having the local courts as Puga, the Shrenis and the Kulas. So we see that in ancient India, also in the ancient perspective, these methods of dispute resolution was existing. Next slide, please. Next, we see that there were developments post 1772 with Bengal Regulation Act 1772 coming into existence that was promulgated to other presidency towns. As you can see, Bombay through Bombay Regulation Act of 1799, Madras Regulation Act, etc. Also, birth of India's first legislative council that was formed in 1834, followed by the first Indian Arbitration Act on 1st July 1899. The award, as passed in an arbitration, is nothing but a compromise between the parties. So we see that even though we have the modernized legislations now, and now we are talking about having ICT and ODR in place, but the concept that is under discussion is an age-old concept, and it has its roots in all these legislations, treaties, and conventions, as what we have discussed. Next slide, please. Significant development was made by 1940 Arbitration Act. A few important highlights are that this act was based on English Arbitration Act of 1934 that prevailed in the British regime. Then in 1937, India became a signatory to the Geneva Protocol on Arbitration, clauses 1920. Arbitration Protocol and Convention Act 1937 was enacted in India to give effect to the said conventions. Then India became signatory to New York Convention in 1960, on account of which the Foreign Awards Recognition and Enforcement Act of 1961 was enacted. And then we see the later developments when Arbitration Act 1940 was replaced by Arbitration and Conciliation Act of 1996. And after that, we have various other amendments in the Arbitration Act, notably 2015 amendment, 2019 amendment, and the recent amendments in 2022, etc. Next slide, please. So this is what comprises of our alternative dispute resolution system. We have arbitration, conciliation, mediation, negotiation. We have dispute settlement through lok adalats, and also we have the modernized concepts such as MEDARB, MEDOLA, ARBMED, etc. It is worth noting that these modernized concepts are exhaustively practiced in the United States, though in the South Asian perspectives, we do find that a lot of innovation is required to be made in this area, wherein two or more techniques or two or more methods of arbitration or ADR can be combined together to get the desired results. Next slide, please. Considering mediation, because if we see the role of SARCO, also, SARC Arbitration Council is emerging as a platform to resolve the disputes not only related to arbitration but also mediation and conciliation. Now, if we see the alignment in the international law and in the Indian perspective, we find that mediation is very much the part of alternative dispute resolution. So here are the key points of mediation. As we can see here, that focus is on identification of the root cause of the problem and speedy settlement of dispute. It is really cost effective, and it is to be ensured that during mediation, disputes are settled in a time-bound manner. Undoubtedly, mediation tries to achieve the fine balance between the aspirations of the parties and the possible outcome. As we see that in arbitration, the choice of law and the party autonomy, these important principles are well taken care of. And so is with the mediation also. The only thing with mediation is that it is non-binding in nature. Even the conciliation is non-binding in nature, but as far as it comes in the nature of bindingness. After this, alignment with the international principles and significant tool for access to justice. And these purposes are well served with the help of mediation. So when we talk about peaceful settlement of dispute, now we are not limiting ourselves only to arbitration, but we are moving a step ahead towards mediation, towards conciliation, towards negotiation, and also the new practices of MEDAR, MEDOLA, ARBMED, etc. Next slide, please. The main philosophy of ADR, as we can see here, is based on the confidentiality part. Confidentiality, objectivity, principles of fairness, transparency, neutrality, rationality are very important when we consider the philosophy of alternative dispute resolution. The underlying notion is that dispute should be resolved effectively within no time and also in a time bound manner, in a speedy way, in a cost effective way. So here we see that philosophy of ADR is also towards empowerment, towards ensuring party autonomy, towards ensuring the voluntariness part for offering unique solutions. Next slide, please. The purpose of ADR is amicable dispute settlement. It provides win-win situation. It also provides access to justice as well as ease of justice. Also, it aims to offload the burden of litigation, the burden of courts. So now, with this background of understanding ADR, we need to understand that how and in what manner uh, tools of technology can be introduced, online method can be introduced. Next slide, please. Okay, so before this, there is an additional slide for highlighting the objectives under Mediation Act of 2023. This is the recently enacted legislation in India, and the objectives of this legislation are to promote and facilitate mediation, especially institutional mediation for resolution of disputes, commercial or otherwise, to enforce mediated settlement agreements, to provide for a body for registration of mediators, and to encourage community mediation for resolving the disputes at the local level, and to make online mediation acceptable and cost effective process. So here what is worth noting is that it has the provisions of making online mediation acceptable and cost effective. Next slide, please. So if we try to understand the perspective of ICT in ADR and access to justice, we of course should keep in mind the principles of justice, liberty, equality, fraternity, and how in this scenario we can ensure that these processes are helping us to move towards quick resolution of dispute settlement with ease. Next slide, please. The concept of access to justice is important in the light of international principles already discussed, constitutional reflections, free legal aid, and ease of justice. Next slide, please. Now, the pertinent questions with respect to digital innovations in alternative dispute resolution. First question is, what is the importance of digital innovation in ADR? Second question is, how can it improve the results that are achieved with the help of alternative dispute resolution? So there are a few important cases also that highlight the role of online tools and the usage of online systems for dispute resolution and for litigation in general. We are going to discuss that for a few minutes. So as far as the importance of digital innovation is concerned, we know that if we employ digital methods, especially AI methods, then it would certainly help for quick resolution of the disputes. For example, like various innovative approaches can be introduced as such, like having e-depository for arbitral awards. So if we can have e-depository for arbitral awards, then it becomes very easy for arbitrator or for a mediator to see the award that is there and to decide the future course of action accordingly. So one is the employment of AI methods, and second is creation of e-depositories of arbitral awards that can help quick dispensation of justice. So, of course, with the introduction of emergency arbitral awards, online dispute resolution is gaining tremendous significance, and this part of online dispute resolution will be dealt by my co-speaker and my esteemed colleague, Professor Dr. Ritu Gupta ma'am. Before that, there are two important significant cases that should be highlighted. One is the Indian Oil Corporation Limited versus Amritsar Gas Service 2009. And in this, the Supreme Court of India stressed on the significance of having well-defined legal frameworks for arbitration. Also, when we talk about online dispute resolution, we should look at the investment in the digital infrastructure. Uh, Also, there is a requirement to ensure equitable access to technology. We need to see our community digital literacy programs and ensure that the digital literacy gap is lessened at all the levels. And of course, we need to see that if we have the proper infrastructures also in place, like having public Wi-Fi's, hotspots, availability of internet, accessibility of internet to introduce online dispute resolution systems. So for dealing with the next part of our presentation, that is on online dispute resolution and the related cases, I invite my co-speaker, Professor Dr. Ritu Gupta ma'am, to throw some light on the aspect of ODR. Over to you, ma'am. Thank you so very much.
Yeah, thank you so much, Dr. Daksha. And visible to you. If that's so, yeah. And I put on record my thanks to Mohammed Saqib Mangrio and Honorable DG of SARCO, who conceptualized this idea to have this, to invite both of us to express our opinions on the very relevant theme that they thought about these online mechanisms. So digitization is something which is not just happening. Too many things have already happened to work with these technologies, the changing paradigms of these technologies, with special reference to what is SARCO's domain, that's dispute resolution through arbitration. While going through the historical aspect, I found that because one of the idea with which SARCO itself was established, that is to resolve cost effective mechanism to resolve these disputes in the region. So when I talk about this region, the South Asian region, the kind of cooperation that we are looking at, and that is where this kind of dialogue makes so much of sense to me. And when I read, and I'm very sure because all of us are from the region, we understand that comprises 3% of the world's area and 21% of the population. And 5.21%, the data is almost around 21, 22. But the point that I wanted to bring forward, that looking into the statistics, the importance of dispute redressal mechanism, which is outside the court and which is cost effective also. So that is where, on this note, I'll just take up from where my colleague Dr. Daksha, who very beautifully explained the concept, who mentioned all the nuances related, and she left me in a difficult position. Difficult position that now I need to start from the other part, where which again is not only quite difficult, but at the same time, so many other things. Can I have the next slide, please? Yeah, so this is where when I say Indian context, because so many things are happening in the Indian judicial system. So this is where we talk in terms of integration of technological advancements and access to justice, because we want to move to that mode, which is not only cost effective, which is convenient also, which is consumer or the client friendly also, which is impartial also, where we can say that any kind of human interference or any kind of biases can be ruled out. So all of us have been seeing this post COVID thing. These kinds of video conferences and all those kinds of electronic document that have been there. And before I was invited, I never knew that my unpublished paper, which I have written on ODR, it's likely to be published in this November itself. That was about, again, because my specialization area is about private law. So when I work in payment systems, banking, the contract, the agreements that are being made, so there these kinds of digital payment systems also gain quite significance. And there, please have the next slide. I want to bring to your notice that here, when we talk about this EADR, so it's not only electronic mechanism, it's something more. And here we talk in terms of what is the talk of the town today, all those artificial intelligence things, all those machine learning tools, and where we do not have that kind of fixed parameters, what you term as the closed procedures. Please have the next slide, because we here are not only talking about that fixed procedure, but here we need to talk in terms of few more advantages. What are those advantages? Few of them have already been highlighted in Daksha's address also, where we talk in terms of cost effectiveness, we talk for convenience, we talk in terms of efficiency, we talk about whatever is customizable. So we need to focus on that, those kinds of processes where we can tailor make the customizable processes. This is what is the need of the hour, and that is again one of the advantages of this online dispute resolution mechanism. And here we talk in terms of also limiting those biases that I just mentioned, which can come into picture whenever any human interaction is there. Please have the next slide. What is the main advantage then? So one is not only that we are going to redress the problem that has occurred or the dispute or the risk that is involved, but also we'll talk about dispute avoidance. And if it is unavoidable, then we talk about containment, that wherever it is, please let it leave at that stage and let's not escalate. And then we move on to the dispute resolution thing. So this also, you may say that the kind of widespread use that has happened. So that widespread use is something which is required to bring that improvement to the legal health of the society, where, as I talked about private law, because private law works on trust, confidence, and that is one thing which is required to keep the economy of the country and the world going. And that is where we talk in terms of ease of doing business. So the moment that legal health of the society is improved, automatically rest other things will be put in a motion, which is always rising and in positive direction. And this is where you see that integration of these digital courts and this online dispute resolution mechanism, what they are going to do, they have the potential to transform that legal paradigm as a whole. This is what I thought, that whenever I talk about, we need to focus on this integration. Please have the next slide. Yeah. So, because it's not that we are working unprepared. So preparedness has been there, and that preparedness has been very, very promising, which has been very evident. And that digital payment system is, of course, one very, very strong example of this. And the judiciary, the apex court, the Supreme Court of India, the judges, the justices, Chief Justice of India, everybody has been very vocal whenever it has come to talking about the potential of all these online dispute resolution mechanisms. That is one reflected from the quotes of the justices on various platforms. And second, that is evident, like few of the judgments even Daksha cited in her address, and I also have few of them, where you see that that is what sets the foundation for future integration. So we have that Bharatiya Sakshya Sanhita. So that BSS in place of Evidence Act, which talks about electronic records. So that cumulative preparedness of all the instruments, whatever is required, legislations, will of the administration, and at the same time, the judicial system. So put together, they are there to deliver. Yeah, please have the next slide where I thought that I'll talk about Justice Chandrachud, former CJI of India, who has been a leading voice, who has always been advocating for that fundamental shift which was required. And this is what he says, that that is their like perception of dispute resolution and that accessibility that we talk in terms of justice. So that is where he has said that it can be like court centered service, but that can be accessible and that can be technology driven also. And Justice Chandrachud on more than one platforms had highlighted that those kinds of disputes which do not require the traditional court system. So that's why we talk in terms of car accidents, we talk in terms of insurances, so though even check bouncing. So that is where these kinds of mechanism not only save time, they save all those the kind of advantages that I had just mentioned. So they work on that. Please have the next slide. And before I just look into this slide, where again Justice Chandrachud, I just quote, above all, there needs to be a fundamental change in the mindset. Look upon dispute resolution not as relatable to a place which we call as court where justice is administered, but as a service that is availed of. So this was the focus, and something which is not there in the slide, which I'm just reading from the article that I had been writing, where Justice Bobde and there have been the other judges who have talked, who have taken a very, even it has been Justice Malhotra. So there have been many other judges who have talked about this. And it is like, I just quote from one paper which had been published by Vidhi Center, ODR, the Future of Dispute Resolution in India. And there, the opinion of Justice Ramanna, Justice Bobde, who had pointed out that ODR can be an effective mechanism to resolve family, consumer, business, and commercial disputes, and where the importance was explained even in the light of that time, it was pandemic, and then AI as a substitute to the current system. And that is where they even mentioned that this would be the correct approach in today's scenario, because technological involvement makes it more effective, efficient, affordable, and not to reiterate, but yes, this is a speedy alternative. And I quote from articles of 2-3 scholars who have already worked. So I got so impressed with the title itself. I'll just read it for you. It was though in the pandemic 2019. Automated dispute resolution system. This, they talk in terms of ADRS, and they say a proposed initial framework for digital justice in online consumer transactions in India. And here the focal point was to talk about B2C, that business to consumer disputes, and role of ODR there. So that is where they have been talking about that transparency, promptness, uniformity, and speedier access to justice. And one important thing which this paper had highlighted, that was that ODR platforms which handle digital payments. So that digital payment and ODR again go hand in hand, and they say that it enables aggrieved persons to have easy and quick access to justice. And I'm sure the participants must be knowing, and those who do not know, that I'll just mention that UN CITRAL model, United Nations Commission on International Trade Law, that had also been talking about laying down such standards which are acceptable to the community at large. And this is where one more thing, though it is primarily arbitration or negotiation, just mentioned, it can be like combination of all three. So this is where they say that it is often seen as being the online equivalent of ADR. So this is again the importance of ODR. I'll just quickly apprise the participants of two important judgments. One of them is FZE Limited versus Vedanta Aluminium, and another one was Shakti Bhog Foods, where the Supreme Court had provided that in contract we talk in terms of communication, we talk in terms of acceptance. So there the court had said that email, letters, telex, telegrams, they are very much valid means of communication. And then video conferencing, I have mentioned here in my presentation also, I'll come to that also. State of Maharashtra versus Dr. Praful Desai, where the court had accepted the video conferencing to record statements of witnesses, permitting the constructive presence of the parties. So this is where you see the dictum of the Supreme Court of India in all these cases has been towards encouraging. And what they encourage, use of digital technology, of course, that involves all those ODR practices that this particular today's forum is all about. And then if I talk about digital payments, there has been one report. I'll just read from that report, which is on Indian mobile payments, 5x growth by 2025. So when you have more like this digital payment industry, the rising industry, more disputes, and that is where the quick redressal is required because stakes are very high. The transfer of money takes place in just fraction of seconds, and that is where we need to resort to such means more than what we have been doing. So that is where the urgent need to identify and detect the threats and then develop the robust mechanism to deal with them, and then whatever consequential dispute, then we should be prepared for that dispute also. Yeah, please have the next slide. Yeah, so this is where you see not only that one country, but the entire region is welcomes this concept, because again the kind of borderless world we are living into thanks to technology. So we are here talking in terms of increasing number of international businesses and arrangements, and whatever it offers, because it's a package. So whatever is there in traditional ADR, that's already there. Something more, and more toppings, more profitable, more lucrative, and easy to access. Yeah, next one. Yeah, this one, I was talking about this Dr. Desai's case, which had happened way back in 2003. And there they had said that Arbitration Act itself enumerates that in an ADR process, when the award is declared, it can be exchanged via emails by sending scanned copies. And today we have, of course, far more newer legislations which highlight the importance of online statute. Yeah, please have the next one. Online provisions, I meant to say. Yeah, the next one. Yeah, so here you see, because it's the will of the executive, and that will of the executive is what prompts all other institutions, be it the central bank, be it is the MSME sector, be it the Department of Law and Justice or Department of Legal Affairs. So this is where everybody, so all the institutions, they have been individually working to provide that online redress, and cumulatively as a country they are able to deliver. So this is where you see that ODR policy for digital payments, MSME talks about Samadhan portal, then Department of Legal Affairs, which is trying to process and collate the details of ODR service providers across the country. So these are not the significant, not only the significant developments, but in addition to that, if I talk about Payments and Settlement Systems Act 2007, so that is also where you will see that they have that ombudsman scheme for digital transactions 2019, and that is also where the grievance redressal mechanism, that is prompt, cost-free, and whatever the situations of inadequacy of client administration that they are going to address. So this is how that online system, especially because when we talk in terms of payments, so that is where all these things become important. So it's not that we do not have any disadvantages, but the point is, more we talk about advantages, gradually will work to redress whatever disadvantage that can come. Like in terms of if I am a private law person, we are concerned more with payments, we are concerned with transactions. And what about if we have failed transactions? So that is where we need to have that system in place. Please have the next slide. Yeah, please. This is where. So these are few of the legislations which have been old, but 1996 Arbitration and Conciliation Act, we have 2000 IT Act, then we have this Mediation Act, 2023 Mediation Act. Many things have been taken up by Dr. Daksha, and mediation is something which is going to stay. So Indian judiciary is working very hard to put this mechanism, especially say in family matters. So family matters, again, these are very heavy matters where, but mediation is something where the parties are there and they are able to handle. And of course, I'll just put emphasis even on negotiation. So this is how mix of all I think is going to work. And then we talk about this 2018 United Nations Convention on International Settlement Agreements resulting from mediation 2018. Yeah, please have the next slide. Yeah, this is what we derive. This is what is the positivity. So whenever any positivity flows from the system, this is where you see that clarity on enforcement of final agreements. So since, as I said, that whenever we talk about enforcement of the promises, this is where you can remove uncertainty and bring certainty that whatever is the final agreement, you can enforce that, and that clarity is very well known to the parties. The moment the parties are convinced, that is where half of the job is done. And whatever the technological advancements are happening, acceptance is the only tool, only way. If we do not accept, then technology becomes smarter and we keep on becoming, one step lesser. So ultimately, we are deprived of, but the uncalled for elements, they are going to use all those technological advancements. That's why these kinds of things we need to keep in mind. Yeah, recognizing the growth of ODR and its effectiveness in addressing, of course, cross-border disputes is also easy. One doesn't have to book the flight, one doesn't have to travel all the way, one doesn't have to sacrifice the current obligations of his or her job, and you just don't need a physical space. So the way today all of us from various jurisdictions, especially South Asian region, we are there talking together this important aspect of ODR. This is where we realize the importance. We save time, we save money, we save energy, and lot many other things. And ultimately, the way my co-speaker mentioned, it's a win-win situation. So this is where you see, then again, 2016 UN Commission on International Trade Law, which talked about all these technical notes, and then European ODR platform and promulgation of regulation on ODR. See, whatever new will emerge, we need to regulate, we need to put a limit. If that limit is encroached, if that limit is passed, or some defiance or deviation happens, then of course we need to enforce. So that is where the importance lies. Please have the next slide. Yes, this is where, again, though I have already mentioned, but few more things are there. Whatever I have already taken, I'll not repeat, but this is where you see that again, on every possible platform, we have been talking about this potential. And this is where you see that the kind of NIXI, so that National Internet Exchange of India's domain dispute. And then you talk about all those payment mechanisms. Payment mechanisms are, of course, very close to my heart also, because I have been working on that, be it Brazil, Hong Kong. And that is where you see that to ensure that this e-commerce transactions are honored. This is what we need to opt for, where we can think in terms of even public-private partnership. We can talk about gaining public trust. We can talk about even that the service providers are always private players, but still we can create all those, we can always send that message across. Please have the next slide. Yeah. So this is where I thought that my suggestion goes, that wherever we are talking about, the practices. So whenever we have that potential, and whenever the see, this ODR mechanism that I have been talking about is on a steady rise. This is where you will see that if we have a separate code, if like say it is dedicated to banking transactions, which provides for arbitration, mediation, conciliation, and negotiation. So then that becomes helpful. And then you can extend the ambit to any other kind of transactions. So the kind of positivity that you gain from this and that multi-stakeholder exercise, that can always be undertaken. So things, sometimes we feel that it is at nascent state, sometimes we feel that we are very advanced, but still every time there is always a scope to improve it further, to plug the loopholes, but to keep on marching ahead so that the collaborative effort that SARCO aims at. So I'm very much with this very with great pleasure, I say that SARCO's initiative in this direction, because every time SARCO has been talking about that collaborative manner for the transformation, right? So this is where we are. So that collaboration in the region is going to help. And that is where we talk about that access to justice. We talk about justice delivery. So that is what we need to look at. Please have the next slide. Yeah. So how do we move ahead? So of course, internet connectivity, Wi-Fi access, whatever is required for whatever makes this digital infrastructure. So that digital space, and not only space, safe and secure digital space. And then we also talk about regulation, not as to throttle, not only to expand, but to have that balance. So this is the balance. I think the way the judiciaries have been across the borders have been working, the aim is to behave responsibly. And that is where even we talk in terms of ODRs, but we need to regulate that also responsibility. And of course, the highest thing is trust building. So that trust building, we need to work on that. The kind of platform SARCO is providing, so together where we can create that trust amongst the players in the market. And what you do, it's not that you just rush up with the technology. It's like you create that awareness, you increase that capacity. So that capacity building in a phased manner. So this is how gradually we can achieve. What is the target? So gradually, the way we are landing on the moon or we are moving ahead in the space, this is how we work even for ODR. And since it is made through human intervention, but to avoid human intervention in transactions. So the contrast, the itself is very interesting, but that brings out the best of the solutions. Please have the next slide where I think because time is up, but again, SARCO as a regional hub can promote this digital innovation in ADR across South Asia. And when we talk about the regional standard setting in South Asia, so this crucial thread is to be held by SARCO, and this pivotal role we just need to hold on, and we need to carry it further. And of course, as we talk, the other initiatives of SARCO, which have been capacity building, which have been training, these are few of the things that I think we can put more emphasis, the kind of technology partnerships we can have, the best of the partners to look into this, and where SARCO's ODR platforms, what they call as interoperable national platforms in SARC countries, that is what we can work on for, so that the cross-border commercial disputes are resolved effectively. And of course, whenever we talk in terms of expansion, that is where we need that regional policy framework also, so that nothing is in disharmony. No disrespect. We just want to align laws. We want to align all the regulations. The way we at South Asian University, it's a proud privilege to work here. Since I come from National Law University, Delhi, before moving to the place, I didn't know that the kind of learning that you have amidst students and faculty from various SARC countries. So it's different when you are inside the system. Outside the system, you see something different. So that alignment, when uh, where I stop talking only for my country, rather I try to expand my vision and my thoughts for the region. That is what is I think is the aim of SAO, that is the aim of SARCO, that is the aim of SARSO. So this is how we can talk about, and of course integrating AI, talking about blockchains, talking about more prediction, so or carrying out those analysis where those predictions can be far more foolproof. And then of course again at the cost of repetition, because that's the essence is efficiency, essence is transparency. Please have the next slide. Because whenever we are talking in these terms, this is where you see. So these were the points which Daksha had touched upon. And after that mediation, we have this access to justice, the kind of perspectives I try to take, and then this digital innovation and this collaborative vision. So this is what both I and myself and my colleague Dr. Daksha, we try to take in this address. We try to be very, very minimum technical and maximum accessible through this discussion. Please have the next slide, by which I can say thanks to all the participants. Thanks to SARCO for having invited us for this wonderful conversation. The topic was very well thought of, and giving us this platform where people who are associated with SARCO, so that is where I could think about. And now both of us are ready to take on the questions. Over to Mr. Saqib. Thank you so much for listening to both of us patiently. Yeah, over to you for questions.
The pleasure is
Yeah.
ours, Dr.
Yeah.
Gupta and Dr. Sharma. So thank you very much for the very informative overview. I really like some of the suggestions that were placed, especially with regards to the interoperable platform, a digital platform. I mean, SARCO is a platform for dispute resolution, but a digital platform to provide a forum for disputes and online dispute resolution, that would actually play a really great role for us and for the region as well. Before we move towards the question answers, I think we have some questions already mentioned. I actually have one question which I wanted to ask. There was some recent controversy, if I remember correctly. The Zoom platform on which we are currently right now, they changed their terms and conditions very recently to say that they can maybe use online recordings and online whatever data is shared for their own AI data learning. Has there been any development in India to make their own platform specifically for ADR?
Dr. Daksha, would you like to take?
So as far as this controversy is concerned, I think that as what is stated, that ODR is already integrated in our systems. Interestingly, as what Professor Ritu Gupta ma'am was stating, that Supreme Court is efficiently employing the methods related to ODR. We have SUPAS, that is Supreme Court Portal Assistance in Court Efficiency. So like already there are examples that exist and that showcases that we are integrating these online technologies in our system. Coming to the controversy with respect to the usage of Zoom platform. Again, like as we can see that we are deliberating, we are discussing this aspect on the platform. Again, it is the matter of I believe that it is the matter that does not only lie with one jurisdiction, but this becomes cross jurisdictional matter, and that's how I think this has to be addressed.
Yeah.
But as far as the details are concerned,
Yeah,
I
Dr.
really
Daksha, I'll
need
take
to
on
check.
from here because what I remember for Lok Adalat and for mediations, they have been using what they call as SAMA. So SAMA they call it, and there again it has resolved a lot amount of disputes, which is an Indian platform, of course, and then we have IDRC. So Indian Dispute Resolution Center is there, which works for this paperless and enforceable arbitration. And then what the other one that I remember, there are a couple of more ODR services like Just Act is there, Smart is there. I said that I tried to make it more simple rather than technical. But yes, it is there. And there is one Center for Alternative Dispute Resolution Excellence also there, which again works for this online arbitration process. So this is where I think that would answer Mr. Saqib's question, if I'm correct. Mr. Saqib, anything else that you wanted to ask?
No, that's it from my end. I think we can move towards the chat question.
Sure.
So the
Sure.
first question is for Professor Dr. Gupta.
Yeah.
Where should AI be used and not used in EDR workflows to improve fairness without eroding due process?
Again, very good question from Saim. So here, what I want to say, see, AI is something with which all of us will have to live. So AI is going to stay for the time being. This is what I know. So whenever you are talking about AI, wherever you can use, but the only thing that we have to be very cautious, and due process will be evolved gradually. So if I talk about academic writing, so like even in academic writing, wherever any sort of help is being sought from these AI tools, now Turnitin and many other tools, and even the academic excellence can catch those AI generated work. So this is where I believe that I don't agree that these AIs are going to erode the due process. Rather, they will pave the way for better processes in place.
Thank you. Thank you, Dr. Sharma. Next question. What minimum standards/practices should SARCO champion so cross-border digital EDR actually works?
Yeah. Daksha, would you take us?
All right. So as far as SARCO is concerned, I think it is my privilege that I got opportunities to work with SARC Arbitration Council. So the question is about minimum standards, practices should SARCO champion. So cross-border digital ADR actually works. Very interesting question. And I think as what has been shared by my senior colleague, Professor Ritu Gupta on this, that ma'am has stated that there is a requirement to have SARCO ODR platforms, interoperable systems. Also, it is in the previous months, I got to learn so many things about the way SARC Arbitration Council is functioning. So already they have the system of having emergency arbitral awards. They are working on the system of e-repository of the cases. So I think that whatever best can happen in this scenario for introducing these tools, SARCO is up for this, and SARCO has already incorporated these changes and is in line with the good practices. That's all from my side. I hope the query is answered.
Just one second. So I think our DG will like to just add on to it.
Yeah, sure.
I think we misfired the question. It was, I guess, addressed to SARCO. But anyway, I think I more or less agree with whatever Dr. Daksha Sharma has said. And in fact, other participants may not be aware of this, but two professors are aware, quite aware, and we are doing a research study right now. So one of the areas we are lacking right now is in terms of getting case referrals. And two professors, and along with other one gentleman, is doing a research. And we are expecting one of the outcomes or rather the recommendations of this research study will be how to optimally utilize the IT capability in the SARCO. So in the light of these anticipated recommendations, and also right now when we are revising, I mean the redeveloping our own website is not working right now. We are redesigning, and everything will be up and running by December this year. And one of the tab we have provided in our new website is exactly this, the provision for online filing and other aspect. But of course, right now we are making provision only in the website, but I guess it will take a lot of time for us to figure out. And also, not only the that online facility will work within the Pakistan or some particular member states, but how it will work across the 7 member states. I think that one, I think we are looking at it, and we will take it very seriously. Thank you.
Thank you.
Thank you, sir. We'll move to the next question. How should identity, evidence integrity, and audit trails be designed so ODR outcomes are trusted and enforced well? Basically, how can we put our trust in online mechanisms?
Yeah, very good question, Barrister Anjum, because here what we are talking about, see, the way we have been using all these, online callings, we have been using all these WhatsApp and other parallel services, you see that kind of encryption which is provided.
Yeah.
And the codes and the passwords and the OTPs. So all these things, the way we use in our day-to-day services, this is where we need to understand the way when we are calling our friend or our family member, we know that no third person is hearing, right? So to the best possible way, we can, have that confidentiality, we can protect the identity. And of course, see, till the time anything is compromised, see, frauds have always been there, problems has always cropped up. So the point is, to the best of my understanding, any technology is always, we should think in terms of tools, right? So the moment we use it as tools, we design the all those parameters through which what is impenetrable, right? So this is what we try. But even then, if some problems crop up, we'll work on that. So trust is the basic thing with which we start, and that will fetch far more enforceability in relations.
Thank you, Dr. Gupta. Next question. What design choices will make digital ADR easy for SMEs, small and medium enterprises, and smaller cities, affordable pricing, local languages, and mobile first? So basically, which one of these three may be more good to advance digital ADR?
I think whatever design you choose, so that has to be friendly to that particular region. So looking into the complex issues of that particular region, be it language, be it weather, climate, be it the geography. So looking into that, I think you can choose any, and involving the private players. That I think is going to go a long way. So that faith in that public and private system, they need to work together.
Thank you.
Yeah.
Thank you, Dr. Gupta. Last question in the chat, at least. What single digital reform would most reduce time and cost in India-seated ADR this year?
Dr. Daksha, would you like to take this?
Dr. Sharma, you're muted.
Daksha, you are on mute. Yeah.
Sorry. So I think that we have already answered this question by stating that we have SUPAS, that is Supreme Court Portal Assistance in Court Efficiency, and we see that how online tools are used for these purposes. For example, reading case notes or making important highlights with respect to few cases, or to see the case-wise distinction of different areas. So I believe that this digital reform related to ADR, related to case management, has already happened. And also with the introduction of artificial intelligence methods, we are seeing that various private entities are also coming into picture, wherein these apps are using and introducing the chatbots, with the help of which, they say that dispute resolution mechanism can be designed. So again, this is very innovative in the aspect. But yes, as what has been discussed by my esteemed speaker, and that that with these technologies, trust factor should be built up. That is very necessary. And how we are going to cross check the result, and how we can maintain that ethical standards when we are using AI and online tools together. So I think that this is what I want to sum up. Thank you so very much.
Thank you, Dr. Sharma. I'd just like to invite actually our governing board member from Pakistan, Khurram Saab, who is also from the Ministry of Law and Justice. Sir, if you would like to have any comments or any questions with our two esteemed speakers.
Yeah, thank you very much. I think it was a very informative session, and I'm really glad that we have very good resource people, Dr. Darsha and Ritu Gupta. They have made this webinar very informative for everyone and make everyone understand from a very logical point of view. And I believe that, that this kind of webinar, if we have get an opportunity to get some more details into this, because right now I think it was in an overview of the entire things, how it works in India. But we wanted to get more details so that we can, replicate the same kind of model here in Pakistan and in other SAARC countries as well. So I would appreciate if you can get the more details into this, and to make it more practical and more understandable for the rest of the participants as well. But up to now, I have found it very informative and very knowledgeable. Thank you very much. I really appreciate the way they have, made their presentations in a very fine manner, and it was very appreciable. We really appreciate the way they have talked and the way they have deliberated upon this issue in a very good manner. Thank you very much. I really appreciate that. Thank you.
Thank you.
Thank you, sir. Thank you very much for your
Thank
time.
you so very much, sir.
Thank you so much for your kind words.
So there are no other questions by the chat or maybe any of the others participants. Yes. I think we can move towards the close of the session now. So coming to the end, thank you very much, everyone, for attending this webinar, being part of this. And my heartfelt gratitude to our two esteemed speakers, again, Dr. Sharma and Professor Dr. Ritu Gupta. The webinar provided very comprehensive, very informative information on a number of aspects, which obviously, as mentioned by our respected GB member, that we also would like to replicate. I also saw the Mediation Act of 2023, which has been enacted in India. That's something which we can also take some inspiration from, because we are also very recently the signatory of the Singapore Convention on Mediation. And I think that could play a very strong role and strong part in helping us pave the way for that as well. With respect to the paper that you mentioned, Dr. Gupta, we do look forward to receiving that and maybe reading that up, and maybe we can also
sure, I'll share soon.
Make it part of our repository. And lastly, just thank you very much. This webinar's focus has been to knowledge sharing and to get the relevant insights so that we can help develop and build upon these insights for our later sessions as well. So again, thank you very much everyone for joining. And if anyone would like to just amongst you say any last words, so please.
From my side, it's really overwhelming because with SARCO, this was my first interaction to this extent. And because, of course, I, along with Daksha, because I joined later and Dr. Daksha was already working with you for the project. But I really found it very interesting. I really found it very relevant. And I appreciate the vision and the choices that SARCO is making. So from SAO side and Faculty of Legal Studies especially, I am ready to commit that whatever new ideas, whatever innovation that you require for this project, not only for this, but for any other initiative, we are always ready to help you with our best possible potential. Yeah.
Thank you, Professor Gupta.
Yeah.
Dr. Sharma, would you like to say any last words?
So I just want to express my gratitude to SARC Arbitration Council, especially Honorable Director General, Mr. Dorji, and you especially, Mr. Barrister Mangrio, and all the participants who are there in the gathering, and Honorable GB member. So these words are not only to thank you, but also to inspire our studies and focus towards alternative dispute resolution mechanism, because this is the need of the time, that we should introduce our systems so that we are able to resolve the disputes in the best possible manner. So again, as what my esteemed co-speaker has mentioned, that both of us are extremely thankful for introducing us to this new topic, very innovative, and especially SARC Arbitration Council and my esteemed colleague who has guided me through various new aspects of the presentation. Thank you so very much.
Thank you. Thank you for the very kind words.
Thank you.
We'll be now ending the webinar. So thank you, ladies and gentlemen, and we'll be concluding. So until next time. Okay.
Yeah.
Take care.
Thank you.
That's quite an informative session.
Yeah.
Thank you, Dr. Daksha and Dr. Ritu Gupta. Thanks a lot. And Shashank Shekhar, Advocate, Supreme Court of India.
Thank you,
Okay.
sir.
Thank you,
sir.
Shekhar. Thank you so much. Thank you.
Thank you so very much, sir.
Bye-bye.
Thank you.
Thank you.